Hi, everyone. Thank you so much for joining us today to talk about your rights as commercial tenants. My name is Ritu Mahajan. I'm the directing attorney of the Community Development Project at Public Counsel, and I'm presenting today with my colleague Kavita, who's a supervising attorney in our project. Today's presentation is going to be to help you understand your rights as commercial tenants, and we will also be providing information on a new law that took effect as of January 1st, 2025. It's called the Commercial Tenant Protection Act, also known as SB 1103. We will be saving time at the end of the presentation for questions. But if you do have questions as the webinar is being provided, you can ask them using the Q&A function, and we will try to get to them, the fastest we can. Thank you so much. And let's go to the next slide, please. So first, I just want to quickly describe our small business legal aid program for those of you that may not be familiar with it. Through a partnership with the Los Angeles County Department of Economic Opportunity, the City of Los Angeles Economic Workforce and Development Department, Public Counsel and Bethzetic Legal Services have teamed up to provide assistance and relief to small business owners impacted by COVID-19. Through this partnership, we're here to easily connect small business owners with legal experts who can provide them with, basic legal information and guides to one-on-one legal representation to help them address their immediate and long-term legal issues. Now, also because of the recent wildfires, we have also been assisting small businesses and nonprofits that have been impacted by the wildfires. So in later slides, you'll see how you can contact us for the free legal assistance. And we also have a bunch of publications and resources that we've put out to help folks that are impacted by the fires. Next slide, please. So just to give you an example of the ways in which we assist small business owners, and also actually Public Counsel does provide the free legal aid to nonprofits that are serving low-income communities. We help both small businesses and nonprofits with a variety of legal issues. We help them with for example, with drafting and reviewing contracts, choice of entity advice and assistance creating entities, drafting and reviewing leases. We help with filing for trademarks, patents, and copyrights. We provide employment law advice. We negotiate debt, including commercial rent debt. We help with issues specific to childcare providers. And we also help with issues related to your website, such as terms of use and privacy policy. Next slide, please. How to get help. So you can apply online for our services. Here's the link. We also have a phone number you can call and leave a message, and we'll call you back. And then you can also email me, Ritu. This is my email address, and this is Kavita's email address. We're always open to helping, so please get in touch with us if at any time you need legal help for your small business or nonprofit. Next slide, please. So this is just a quick disclaimer, letting you know that this presentation is only to provide general guidance and shouldn't be construed as legal advice. The law on the topics we're going to be discussing today is really context specific, and this information that we're presenting today is current as of February 2025. So just quickly, I will go over our agenda, and I think some folks are asking if the training today is going to be offered in Spanish. Unfortunately, this one is just in English, but we should be doing a Spanish and English one in March, and so I'll definitely share that information with you as we have it. So today's agenda is I'm going to first discuss SB 1103, the new law that took effect as of January 1st, 2025. Then we're also going to discuss general commercial lease issues and protections, what happens in the event of a lease being terminated, and then we'll save time for questions and answers. Next slide, please. So SB 1103, the Commercial Tenant Protection Act, became effective January 1st, 2025. one really big thing to remember about this law is that it applies only to qualified commercial tenants. And qualified commercial tenants is defined by the law as micro enterprises with 5 or fewer employees, restaurants with 10 or fewer employees, and nonprofits with 20 or fewer employees. The types of protections that this law provides to qualified commercial tenants include protections related to language access, extended notice periods for rent increases and termination of tenancies, and standards and transparency with respect to building operating costs. Next slide, please. I think it was the last slide. Okay, so SB 1103, as I said, became effective January 1st, 2025. It applies to leases executed or tenancies commenced or renewed on or after January 1st, 2025. It also applies to month tenancies. So this is, for some of you, your lease may have ended and you continued to be a tenant and your rent was accepted. And so then your tenancy converted into a month-to-month tenancy. SB 1103 also applies to leases executed or tenancies commenced before January 2025 if your lease did not have a provision regarding building operating costs. Next slide, please. So how do you exercise your rights under SB 1103? If you are a qualified commercial tenant, you have to notify your landlord that you're a qualified commercial tenant to receive the protections under this law. So you must provide them a written notice, letting them know they are a qualified commercial tenant and a self-attestation on the number of employees you have. We have a publication on this issue and we've created a template notice that you can use to let your landlord know about your qualified commercial status. A self-attestation is basically you signing under penalty of perjury that at the time you gave your landlord that notice, you have X number of employees, for example. I will put the publication link in the chat. Next slide, please. So now I'm going to get into the different protections that SB 1103 provides. The first important piece is on language access. The law requires that you as a qualified commercial tenant be provided a written translation of your commercial lease if it was primarily negotiated in Spanish, Chinese, Tagalog, Vietnamese, or Korean. And this applies regardless of whether or not you had your own interpreter helping you negotiate the lease. If your landlord does not provide you a written translation of your commercial lease, if you had negotiated that lease primarily in one of these 5 languages, then you have a right to rescind the lease. So this is, I'm definitely open to answering questions on this, but this is the first big piece of the law. And the point behind this is that, we have a lot of clients that they've negotiated their leases in other languages. English is not their first language. And then they're provided a 30 to 40 page lease all in English that they don't understand. And they have no idea what they have to do as a tenant, what rules they have to follow. And so this piece of the law is trying to ensure that people understand what they've signed and that both landlords and tenants can comply with the lease. Next slide, please. The next big piece of SB 1103 that's important to understand is this new law provides increased notice periods for rent increases and for termination of tenancies. So landlords of qualified commercial tenants must give those tenants at least 90 days notice if the rent's going to be increased more than 10% and at least 30 days notice if the rent's going to be increased 10% or less. Now this is really a big deal. I know 90 days is still not enough time for tenants to absorb a super high rent increase, but the law before this was that tenants would just get 30 days notice, regardless of how much the rent increase was. So getting 90 days, hopefully does give people a little more time to prepare for that type of increase and time to figure out what their options might be. The SB 1103 also gives qualified commercial tenants longer notice if their landlord's trying to terminate their tenancy. So if the qualified commercial tenant has occupied the property for less than 1 year, they're to be given at least 30 days notice. If they've occupied the property for more than 1 year, they're to be given 60 days notice. So these are the extended notice requirements under this new law. Next slide, please. The other really big piece of SB 1103 is the standards and transparency requirements related to building operating costs. So some of you may be familiar with this term, building operating costs, but often they're also referred to as operating expenses or common area maintenance fees, also called CAM fees. So these are costs that the landlord incurs on behalf of a tenant to operate, maintain, or repair the commercial property. It can include things like maintenance of common areas, utilities that are not separately metered, taxes or assessments that are charged to the landlord for the property that you're renting. This is a huge issue for commercial tenants. We have many clients that pay, high rents, and then on top of that, they pay high operating expenses every month. And what we were finding is that at times, tenants were being asked to pay high operating expenses without the landlord providing any justification for where the expenses were coming from and any documentation showing that the landlord was in fact paying these expenses. So under this new law, landlords must provide qualified commercial tenants with supporting documentation if they want to charge them for building operating costs. Supporting documentation must be a dated and itemized quote, contract, receipt, or invoice from a licensed contractor or a provider of services. And it needs to have, clear information on what the cost is, how it's being allocated amongst various tenants who might be leasing the property. And it has to be signed by the landlord to show that it's true and correct. Next slide, please. So a landlord may only charge a qualified commercial tenant for building operating costs if they provide the supporting documentation and also if these rules are followed, 1 through 6. The costs are allocated proportionately per tenant. The costs were incurred within the previous 18 months or are reasonably expected to be incurred within the next 12 months. The landlord provides a notice before the lease is executed stating that the tenant may inspect the supporting documentation upon written request. Within 30 days of the request, the landlord provides the supporting documentation. The costs do not include expenses paid by the tenant directly to a third party, and the costs do not include expenses which insurance, for example, has paid to the landlord. So basically, this is setting standards around the way in which landlords charge for these costs and how they need to be calculated. It's also putting under number 2, you see a time frame, because we've had clients also that have told us that they're being asked to pay CAM charges from 5 years ago, which they had no idea, they were going to be expected to pay. And then they're all of a sudden given, a $10,000 bill saying you owe CAM from 5 years ago. If you don't pay it, we're going to evict you. So number 2 is trying to address that issue by putting a time frame on how far back landlords can go when they're asking qualified commercial tenants to pay for building operating costs. Next slide, please. So if your landlord violates SB 1103, there's different remedies. As I mentioned before, if they do not provide the lease in your language and it was primarily negotiated in one of the 5 languages that we discussed, you could rescind the lease and say that it's void. If your landlord doesn't follow some of the other protections that I explained that SB 1103 offers, you could use it as an affirmative defense if your landlord files an eviction case against you. Also, if your landlord violates the building operating cost terms of the SB 1103 that I just went over, they could be liable to you in a civil action. So this means that you could sue them for violating the building operating cost section of the law, and you could get damages, attorney's fees, and possibly punitive damages. Next slide, please. Okay, so now I'm going to turn it over to Kavitha, who's going to talk to you a little bit more about some of the key provisions and leases that we want to make sure small business and nonprofit tenants are aware of, because these are the provisions that we see come up a lot when clients call us for legal help. So I'm going to turn it over to Kavitha. Thank you.
Okay. Hi, everyone. Sorry, I have a little bit of a cough. Just to talk about all the terms that you need to make sure you have in your lease agreement, we're going to go over the types of leases, the lease terms and options, assignments, and subletting, default remedies, personal guarantees, notices, insurance, repairs, ADA, and holdovers. Um, and just on this, like the best time to negotiate your terms is in the beginning of when you first move in. Once you're in the lease, it is very, very difficult to change the terms. So I would say, if you're looking at a property or you're coming up for a renewal on your lease, just really look at those terms and we can help you as well at Public Counsel. So if you want us to look at your lease, just reach out to us. Next slide. So in terms of the types of leases, there's a gross lease, modified lease, and triple net lease. So the gross lease is something where you're basically going to have to pay one fixed payment. The tenant agrees to pay, the rent. The landlord's responsible for the cost, associated with owning the property. So, the landlord is going to cover all the expenses related to the building. You're just worried about the rent, right? And that can be good with tenants who want like a predictable expense, and you don't have to worry about the cost changing month to month. More common for these commercial leases, I think, is like the modified lease or the triple net lease. The modified lease is where the landlord is going to be responsible for the costs associated with owning the property, but as the operating costs increase, the tenant is responsible for paying a share of the increase. For example, if there is, if you have a store in San Francisco and your rent is, or like Los Angeles and your rent is 4,000 a month, then you pay the 4,000 a month, but you and the landlord, you guys agree to split the cost of the utilities or the cleaning and, things like that. So it's some of the expenses basically get split. That's how I would describe modified gross lease. And then for the triple net lease, that's the NNN or triple N lease. That means that you're going to have to pay the rent plus some of the costs associated with owning the property, like the taxes, insurance, and maintenance. What to be careful with this is that like sometimes the rent seems really cheap. It's like, oh, I'm getting this property for just 2,000 or 3,000, and everywhere else is paying 4,000. But you then come to find out that, wow, I didn't realize that my expenses were going to be 1,000 or 2,000 on top of that. So, if you're comfortable with a lower base rent, you could accept that. But if you're not sure and you want to find out how much you would have to pay, talk to the landlord and see like what were the expenses the last couple months, right, before you move in. And if they're not really forthcoming, just be careful of that place and also ask other tenants who live, if it's like a shared complex, like ask the other tenants who are there, just be like, how much do you guys pay if they're willing to tell you? Okay, next slide. Okay, so for lease term and options, there's the initial term, which is the effective and commencement date, and then the rent commencement date. So for the initial term, like this is why they have different dates. The effective date is the date that you sign the agreement. So let's say it's today, February 4th, you signed the agreement. The commencement date is the date that actually like you get to move in, right? That's when your lease actually starts. So it basically, oh, sorry, it's when your lease officially begins, even if you haven't moved in yet, right? So basically, if we signed it on February 4th, that was the effective date. Commencement date is, let's say it's March 4th. Um, and so, why that's important to know your commencement date is because certain things like insurance, or you might have to start paying for like the maintenance costs on that date, even if you haven't moved in yet. But usually you can move in by that date. And then in terms of like your um, rent commencement date, sometimes, that's usually when you move in, but also sometimes what happens is they give you like the first month free, for example, if you're moving in. It can happen, like if you're telling the landlord, I have, for example, a bakery and I want to, um, you know, build like the kitchen, inside the bakery before I start my rent and move in. And he's like, okay, I'll give you like 3 weeks to do that before you move in, right? So it's good to know those dates because, for example, if they have you go and pay for insurance, maybe you can talk to the insurance company and say, look, I'm not really moving in till, for example, March or April. So that's when I want my insurance, to start with the costs. The renewal options is it gives you, the right to talk about like, okay, can we extend the lease? This is really important, I think, because sometimes like if you come to public counsel and you need help with your lease, a lot of times what we'll look at is do you have a renewal term or can we get you a renewal term? So let's say you find a really good place, the landlord's great, everything's going well, and you're paying rent, maybe you have a lease for 2 years and your rent is like 2,500. And then, in 2027, your rent might jump to 4,000 or 4,500 or something, right? And of course, there's protections with SB, the new law. But if we can lock you in at a certain price and we can say, you know what, I want my rent to be 2,500 for the next 2 years, but when for the third year or fourth year, I want the option to renew this at only a 5% increase or only a 2% increase. And sometimes they'll agree to that. So you can kind of lock in your future option to renew. And I think that's a really good thing, especially if you're building something in that building, right? Like it's a hair salon, you've put in, like your hair dryers or it's a kitchen or, you don't want to have to move, right? After 2 years if your business is going well. So for that reason. Okay, next slide. Assignment and subletting, so this is that the tenant has a right to possess the property they lease. A sublease is a tenant's transfer of less than the entire interest. It's a transfer of the tenant's entire, oh, sorry, while an assignment is a transfer of the tenant's entire interest. Sorry, I messed that up. Most leases contain restrictions against assignments and subletting. With assignments and subletting, tenants usually remain liable for its obligation under the lease. For example, if a subtenant or assignee does not pay the rent, the tenant is responsible. So, one thing you want to keep in mind is if you have a very big unit, like for example, we talked about, a hair salon or whatever it is, um, are you going to be able to rent out part of that unit to another subtenant? If it's a really good big place and, it's kind of expensive, you want that right to rent it out to other people, because you might want to rent out a station, for example, or you might have a kitchen where you only use it for Monday through Friday, but you want the kitchen to be used for maybe a caterer who's going to come in, on certain days a week to use that kitchen. So just make sure that it's in your lease so that later the landlord doesn't say, oh, I never allowed you to do that, right? And so you just want to make sure that's all very clear. Next slide. Okay. So for default and remedies, so the landlord is going to have certain obligations that if they default, then you are able to, for example, sue for breach of contract. And that might be things like maintaining the premises or abiding by other obligations that are inside the lease. And if they don't do that, then you can sue for breach of contract to get your damages, or a constructive eviction. For a tenant, you have the certain obligations as well in the lease. You have to pay the rent, you might have to maintain the property in a good condition, you might have to have adequate insurance. And the landlord is going to be able to evict you if you don't do those things. And they can also apply your security deposit And then, and then basically sue you and terminate the lease. Just one thing to make sure on here is that with commercial tenants opposed to, home rent tenants, there's usually less protections, right? Of course, Ritu just talked about all the new protections, which are really good, but a lot of times it's kind of easier for the landlord to sue than the tenant to sue. Um, and a lot of times it's because the lease favors the landlord, right? So we have a lot of cases where when it was raining last year a lot, this year obviously we didn't have enough rain, but last year when it was raining a lot of places flooded. And we had a lot of tenants who had commercial tenants who had things like, maybe a carniceria or butcher shop. We had a person who had a tea shop, just all sorts of different shops where um, the roof started leaking, and it started leaking a lot. And the it completely like devastated their business. Their computers got fried, their cash registers got fried, their equipment got damaged, and the landlords just would refuse to fix anything and said, well, in the lease it's not our obligation, right? Plumbing's not our obligation. You have to fix it. So that's why we really encourage you to look at the lease language and to also, if you have a question, just talk to us. You could also potentially talk to your landlord and say, look, if there is a problem with plumbing, I would agree to split that cost with you, right? So that way, maybe the landlord's like, okay, we'll go 50-50 on this, for example. Okay, so next slide. Sorry. Accidentally muted myself. For personal guarantee, one thing that is, the landlord can protect against a tenant for not paying the rent or breaching the lease by having a third party execute a lease guarantee that makes the third party liable for the tenant's obligations under the lease. If a small business owner has a legal entity, it is preferred to enter into the lease as the legal entity and not provide a personal or third party guarantee. So what this means is that, let's say you have a company and it's I don't know, let's call it like Valentine's Bakery since Valentine's Day is coming up. Okay, so, and your Valentine's Bakery is an LLC or some kind of, some type of corporation. Um, if you enter the lease, you could just sign it as Valentine's Bakery. But if the landlord asks you to personally guarantee it, so they say, you know what, John Doe or Jane Doe, you have to go and personally guarantee this lease. That means that if something was to happen and you couldn't pay, like maybe the roof collapsed and the landlord doesn't want to pay for it and you want to move out, or you just don't make enough sales and now you have to pay this really high back rent. Normally they would just be able to sue Valentine Bakery, right? The company or the corporation. But if you personally guarantee it, or you have maybe your cousin or your sister or somebody do a third party guarantee, then they can come after that person, right? And say, well, now you have to pay me for that. So if it's possible, don't agree to personally guarantee it. Just say, oh, you know what, my company's just going to sign. I'm going to sign on, my company behalf only. But if they make you, then you just have to think about it. Like, is this place, does it make sense for me? Is the lease fair? And is the rent okay? And then maybe personally guarantee. Okay. Next slide. Okay, repairs and maintenance. So the lease should clearly state who is responsible for the lease and repairs and maintenance. That's, the example we just talked about. Unless the tenant is leasing the entire building, landlord will typically be responsible for maintaining the common areas, structure, exterior, and building systems like the electrical, plumbing, and HVAC systems. But again, check your lease because sometimes they don't cover the plumbing or electrical. But hopefully they do. Maintenance of interior is usually the tenant's obligation. The tenant's share of the CAM, which is, the common area maintenance fees, that is usually calculated by dividing the square footage of the tenant's premises by the entire square footage of the building or project. The commercial tenants cannot make repairs or perform maintenance that the landlord has failed to do and take a credit against the rent unless this right is spelled out in the lease. Just on this one really quick, basically, the CAM charges, be careful of those too and see what they say in the lease, because we had someone that had a tea shop, like I mentioned, and suddenly, there was like 10 different shops in that premises and a huge hotel and a restaurant, and they were making her pay like 75% of the electrical bill, right? So if you just have a small shop in the property, it's fair, I feel, or you guys probably feel, it's fair that you pay your share based on your square footage. So just go ahead and check that. And then, and if you do a repair to your property, don't expect the landlord to pay for it, right? You want to make sure that it's spelled out in the lease or get it in writing with the landlord. It's not like a house, thing where the landlord doesn't fix like, your bathroom, and you keep asking them, and then you go ahead and charge it to your rent and say, I'm not going to pay half the rent this month because I paid for that thing to be fixed. In a commercial lease, you have to be more careful. Okay, so just make sure it's either in the lease or in writing. Next slide. Notice. So the landlord may give notice of an increase in rent, termination of the tenancy, modification of the lease, if they're going to enter onto the property. And SB 1103 gives the guaranteed notice period, right? So as Ritu mentioned, if the rent's going to go up a certain percentage, they have to give you 90 days notice or maybe 30 days notice. It depends on how much it's going up. So look at that whenever you get an increase. Just check with the SB 1103, or you can call our office and we can help you look into that. Next slide, please. Insurance. Okay, so your lease is going to tell you, is going to require you usually to obtain insurance that covers liability for personal injury and damage to the tenant's property. Tenants should make sure that the coverage is available in the amount requested by the lease. Maintaining the insurance required by the lease is important because failure to have this insurance would be breach of the lease, and most leases state that the landlord cannot be held responsible for the damages to the tenant or its property. So for this one, again, you want to make sure that when is the date that the insurance starts, because if you haven't moved in yet, it's possible you can ask the landlord that you want your insurance to start on the day you actually move in. And then, look at what they're requiring, because sometimes in the lease, they say that you have to have like 5 types of insurance. They might say you have to have workers' compensation insurance, environmental insurance. Some of the stuff may not even apply to you, right? So why would you want to go and pay extra for insurance every month when those insurances don't apply to your type of business? But of course, if they have you get like a business coverage insurance, that's pretty standard, and that's something you should probably have yourself. So if you want us to help you look at that, again, just go ahead and give us a call and we can help you. And we can also potentially even email your landlord and say, look, this guy has a bakery or has, a mechanic shop, and he doesn't really need this other type of insurance that you're asking him to get. So we'll just go ahead and get this, this one insurance or 2 insurances, not all 5, and see what the landlord agrees to. And then also, maintaining the insurance is important, as it says, like, a lot of times people just get insurance for like a month, they stop paying it, and then if something happens and the landlord realizes you don't have the insurance, then you could be in trouble for that. um so just make sure about those clauses. Okay, next slide, please. For ADA, you want to make sure that the lease states that the landlord is delivering leased property in compliance with all accessibility standards. As a best practice, the tenant should make sure the lease addresses whether the landlord or tenant is liable for any ongoing cost or ADA compliance. So this is something that we can help you at Public Counsel look at. Because a lot of times you guys must have heard there's a lot of lawsuits. Sometimes they're valid, but a lot of times they're also maybe someone taking advantage of the ADA laws. And maybe they'll come to your business and say, oh, you know what? The counter wasn't low enough for me, and I have a certain need or disability, and you now have to pay me, or maybe your website, or, certain things they might just go ahead and say that you made an ADA or disability violation. So you want to make sure that the property is already in compliance with the accessibility standards. And so if you can get that in your lease, that it's already being delivered to you in that way, then if you were to get a lawsuit and someone sues you for not having, for example, a wheelchair ramp, then maybe you could say, well, look, I thought that was the landlord's responsibility, or the landlord should be paying a lot of that instead of me. So just go ahead and look at, what the lease says about ADA compliance, and we can again assist you with that. Next slide.
Also, sorry, just really quick, this ADA thing is a huge issue. So, please, try to think about, what you might be sued for related to ADA before you actually get sued. And we have a publication on this that can help identify some of the common ADA, issues that come up in lawsuits. So we're here for you. We can give you advice. And I know, it's a huge problem for small business owners, but there's also ways to comply. And so I will put the publication in the link.
Yeah. No, that's a great point, Ritu, because Ritu's helped us helped a lot of business owners settle those, because I mean, it's the worst thing where you're barely making it, or you're finally making a profit, and then someone comes and sues you and says, "Oh, you know what? I want $20,000 because I didn't have a parking, that was accessible to me," right? So you don't want that type of obligation. And those cases get very tricky because the landlords often say, if you try to fight it, even if we win by a small amount, like $50, let's say it goes to a court and you win by, the jury says, okay, fine, let's give the guy, $500 or something. You then have to pay all my attorney fees as well, which is why a lot of times it ends up being negotiated and you have to dish out some money in most cases. So go ahead, that's, as Ritu mentioned, it's very important to look at that, the ADA clauses, um, and look at that publication as well that she mentioned. And the last one that I'm bringing up here before I switch over to Ritu is holdover and surrender. So, look for the holdover term in your lease. Is it an automatic increase? And if you want to renew your lease, start the negotiation early. Um, and then the removal obligations, movable personal property, trade fixtures, signage, abandoned property. Okay, so, in terms of this slide, what it is that, let's say, you have a shop, maybe it's, like a hair salon, and you go ahead and you're renting it out. Everything's great. You've set everything up. You've put in, the hair wash stations, the blow dryers, the counters, everything's there. And you want to increase. You want to go ahead, and you've already been there for 2 years, business is going well, so you want to go ahead and rent it for another 3 years. Well, what if you just stay there and then you keep staying there for another 3 months, 4 months, and then you never really talk to the landlord about how much your rent actually is going to increase? You don't want to be surprised, right? Where the landlord says, "Oh, you're paying 2,500, but actually now I'm charging you a lot more," right? So it's very important that once your lease expires, go ahead and talk to your landlord about how much will I have to pay if I go ahead and stay longer. And if you can get that in your lease early on with that option to renew for just a 5% increase, 10% increase, that's going to be key. So really, really important. It's going to save you a lot of money in the future. Um, and and then the removal obligations, the movable personal property, if you've go ahead and, you've put up decorations or like certain, chairs and desks, then obviously you can move that out, right? But where it gets tricky is if it's a trade fixture, right? And you, in that hair salon, you've, installed certain, um, you know, blow dryers that stick to the wall, and you have like certain desks and mirrors and, things that have really just changed the property that you cannot easily just pick up and move, but it's actually attached to the property and it might cause damage. It's bolted down. That type of thing is going to be a little more tricky. Is the landlord going to say, actually, I thought this was ours, right? Because we helped you with this. It's more important, hopefully you're most likely you're able to take that with you, but it could cause damage to the property. So you just want to make sure that it says in there that you're able to take your fixtures as long as it doesn't cause damage to the property and they belong to you. We had a case very recently where someone had a jewelry store and they moved in. It was a very, very old lease. It was like a 30, 40-year-old lease. And when the guy moved in, he was a young guy. He put in like in the walls, like panels, the wooden panels to change the whole dimension of how that place looked. And when he moved to the new place, because suddenly they wanted to kick him out, of course, because they're going to get, more rent with someone else. He was like, well, what about my wooden panels? And luckily he had in his old lease that these are his wooden panels and they belong to him, and he was able to take it with him to the next property. So it just makes it a little more clear if it says in there that your fixtures belong to you and you're going to be taking it with you when you leave. And any abandoned property, if you leave stuff in there and you get in a fight with the landlord or whatever, and you're like, you know what, I'm leaving. Okay, just be careful because that abandoned property, the landlord has an obligation usually to keep it for a reasonable amount of time. Maybe they can put it in storage or something, while they fix up the property. But you could get a bill and they can say, well, we had to put it in storage for 30 days and you didn't come and get it, and here's your bill for the storage. So just be careful with that, and they may go ahead and dispose of it if you don't go pick it up. And last thing before I switch it over is, talk to the landlord before you move in. See if they seem like relatively, you know, reasonable type of people. They're relatively nice, they're reasonable, they're able to talk to you about the terms. You can go ahead and maybe amend a couple terms. They don't seem overly, greedy, or you're not able to reach them. And, because if you have a bad feeling with a landlord, they may be difficult to work with in the future when some of these issues come up, right? So always, it's important sometimes to go by your gut. And then, second, the best thing, of course, even more than that, is what's in writing, right? And what you have in your terms, because that paper, it can either somewhat harm you or can actually help you, right? So if those terms are more fair to you, then it's going to help you throughout your business. So always look at those terms and, just give us a call if it's time to renew your lease or get into a new lease, because we might have some ideas for you. So I think that's my last slide for until it goes back to redo.
Thank you, Kavita. Um, I recognize this is a lot of information, and so we'll definitely have time for Q&A. I'm just seeing some of the questions in the Q&A, and I'm happy to take a little bit of time to answer. Okay. So Francisco asked a good question about, what happens if a small business gets sued for not complying with the ADA? Um, is that lawsuit for I think what Francisco was asking, is that applicable to the tenant or the property owner? So it's actually both. We've seen lawsuits where both the tenant and the property owner are named as defendants on the lawsuit. And often, unfortunately, what happens is the property owner will tell the tenant, I want you to deal with this lawsuit. I don't want to deal with it. Under my lease with you, it says that you as the tenant are the one that has to comply with all the ADA stuff. And the reason this lawsuit even was filed was because of your business. So you have to deal with it. If I have to hire an attorney as a landlord to deal with it, I'm going to charge you, the tenant, my bill. I'm going to pass the bill on to you. So it is a big issue. We have lots of small business clients that have come to us over the years who've been sued for ADA violations. The publication I linked in the chat tells you what some of the common issues are, but just real quick, people get sued. Most recently, it's been over like not having in front of their front door to their business, they have a little bump or stairs. And for some of these people that are filing these lawsuits and driving by, that's a very easy thing for them to notice and then file a lawsuit. So you want to make sure that if you have stairs or any kind of bump, in the doorway, that you either remove them or you put in a temporary ramp. And if you do put in a temporary ramp, which you can buy on Amazon, it should be on during your operating hours. It can't be like, oh, you just bring it out when somebody comes who's in a wheelchair, for example. If you have an entrance that there's no way to remove the stairs, there's no way to get a temporary ramp, you have to have another entrance where somebody in a wheelchair could potentially get in. So that's been the big, a lot of cases recently have been filed over that. We've also seen cases filed over like the bathroom, the mirror being too high, the toilet being too high, the sink being too high. Also the aisles in like the mini marts being too narrow, not having enough width. It has to be at least 3 feet. Or the counter height being the wrong height, where you pay. And then also we've seen lawsuits over like the dining, the tables. If somebody's coming to eat at a restaurant, there has to be certain dining setup that can accommodate somebody in a wheelchair. So there's a lot to it. Definitely reach out if you need further help or advice on that. The next question is, what happens if your unit is on the second floor in a commercial center built in the 90s and there's no elevator, only stairs? So actually somebody asked us this recently. Um, there I think that our research showed that um, so with these ADA laws, you have to make reasonable accommodations, right, for people with disabilities, as long as it's not going to pose an undue burden. So if something's going to be so unreasonably difficult or expensive, then the law doesn't require you to do it. So for a place like this where there's no elevator and only stairs, I think my argument would be it would be so expensive for a tenant to install an elevator that it's just impossible, you know? And there are different rules in terms of building and safety, and the ADA rules changed in the 90s. So that also could help a tenant, make that argument as to why they couldn't, provide an elevator and stairs should be sufficient. Happy to talk offline also, Lauren. Yes, Tim, the slides will be available after the webinar. We will email them. Um, they're asking about 1103. If you renewed your lease in December 2024, but the new lease term began in January 2025. I think, Tim, I would argue that SB 1103 applies because the new lease didn't start till January 2025. If you need help asserting your rights under SB 1103, please contact us. I linked our online application here in the chat. Pierre is asking, are operating expenses also called NNN fees? Yes, sometimes. So NNN, it refers to triple net. So basically, triple net is a type of lease where tenants are being asked to pay a monthly amount of rent plus the landlord's share of taxes, insurance, etc. Pierre is also asking, does number of employees for SB 1103 include only hourly salaried staff or does it include contractors? It does not include contractors. The qualified commercial tenant numbers are based on employees, not contractors. And then someone asked about insurance. So as Kavita mentioned, a lot of leases have requirements about insurance, right? And they obligate tenants to get insurance and certain types of insurance. Now, if you don't have it as a tenant, you could be in breach of your lease. And I will say that some leases basically say, if your stuff gets destroyed due to a flood or anything, you as a tenant have to use your insurance to cover the repairs and to fix things. So if you don't have insurance, you're kind of at a loss. And then also your landlord can say you breached the lease by not having it. This person asked, if you forget to renew the insurance and there's a claim, who is liable for it? I mean, I would say that you as a tenant would be responsible depending on what the claim is related to. So you'd have to look at your lease, but if in the lease it said you were going to have certain types of insurance to cover your loss and you forgot to renew it and then a loss happened, the landlord, my guess is would say, we're not going to cover it. That was your responsibility. Does pest control fall under building maintenance? It could. I forget. I have to see what the definition of building operating cost covers for SB 1103, but I do think it's basically all costs to maintain and repair the property. Okay, so I'm gonna now go through the next few slides. So this relates to when your lease is terminated, right? So for the lease can be terminated in different ways. Either, your lease ends, and before it ends, neither side has any conversation or agreement about extending the lease or renewing it or allowing you to stay on after the lease as a month-to-month tenant. So that could happen, right? It just ends based on the terms of the lease. Then there's situations which most of our clients are in, they're month-to-month tenants because their original lease ended. They continue to stay as tenants. The landlord accepted their rent and they've created a month-to-month tenancy. In that case, as I said before, under SB 1103, if you're a qualified commercial tenant and your landlord wants to terminate your tenancy, they have to give you at least 60 days notice if you've been there more than a year, for example. If you're not a qualified commercial tenant and you're month to month, your landlord unfortunately only has to give you 30 days notice to terminate your tenancy. And then so they give you that notice, and I get this question a lot. Even during that notice period, you are expected to pay rent. You can't just not pay rent during that 30 or 60 days. Um, and there are rules about your landlord returning your security deposit and what they can use it for. A lot of times the lease will have like the lease governed. So you'll have to look to your lease to see what it says about security deposit. If you do not move out, let's say your landlord gave you a 60-day notice or a 30-day notice and you don't move out within that time frame, then your landlord would need to file an eviction case against you, a lawsuit. Similarly, if you don't pay rent on time, then your landlord has a duty to give you a 3-day notice, letting you know that the rent is due. And if you don't pay it in 3 days, they can take steps to file an eviction lawsuit against you. So that could happen as well, right? And so now, next slide, please. I'm going to just talk about how eviction processes work. So, again, as I mentioned, termination of your lease, it's largely governed by what does the lease say as to how the lease can be terminated. I will say that usually leases don't give the tenant the right to break the lease early. So if your lease is for 5 years and then after 2 years you're like, I don't think it's working out, usually your lease, it's going to make it tough for you to break the lease. We have had success negotiating early lease terminations for clients, but it's definitely like depends on which landlord you're dealing with and how reasonable they are. So we have sometimes had success getting people out of their leases without having to pay like a huge penalty. And we also have clients that just left, year two, they left, turned in the keys, and just hoped that the landlord wouldn't go after them, because technically the landlord usually can say that you have to keep paying the rent until they find a new tenant. So we've had clients who've left, just hope landlord doesn't come after them. Then we have other clients who the landlord did come after them and sued them. So it's ideal to try to negotiate something with the landlord in writing before you leave, right? But that's not always possible, which I understand. So in terms of eviction procedure, it starts with the notice of termination, whether that's a 3-day notice because you didn't pay rent on time, or it's a 30 or 60-day notice to end your tenancy for no reason. And if like I said, if you don't pay the rent within 3 days or you don't leave within the 30 or 60 days, then the landlord will have to file an eviction lawsuit against you. And what that means is they will go to court, file a summons and complaint, and they'll have to serve it on you. Once you're served, you have a certain number of days to respond to the lawsuit. And then a trial date will get scheduled, and then eventually there'll be a judgment. And potentially, if the landlord wins, the landlord gets a judgment in their favor, then the landlord could get this writ of possession, which basically gives the landlord, it tells the sheriff to go put a lockout notice on the property, which will give the commercial tenant a certain number of days and before the lock is changed. Next slide, please. Okay, so on the notice, like let's say you got a 3-day notice. The commercial tenancy laws are different than residential tenancies. For residential tenants, the 3-day notice has to be very accurate and precise. For commercial tenants, if you're getting a 3-day notice about rent, the landlord just has to put an estimate of what they think the rent is that you owe. So it doesn't have to be exact, basically. Next slide, please. And like I said, they have to, if they do decide to file the lawsuit, they have to serve you. And now, because of a new law, you have 10 court days to respond to the lawsuit. Before, the law said you only had 5 court days, which obviously is not enough. And even 10, I would argue is not enough, but it's a little more time. And there's forms online that you can use to file this, what we call answer to the lawsuit. Next slide, please. So you file the answer. You can also do discovery, where you ask the landlord certain questions, that they are required to respond to, and then you can potentially have the case go to trial. At trial, the landlord does have the burden to prove their case, and the tenant is allowed to defend themselves using the defenses that they brought up in the answer. So if you didn't put any defenses in the answer, you're limited in what you can say at trial in your defense. Next slide, please. So if the case goes to trial and there is a judgment, the judgment will make it clear who won, right? Who's the prevailing party. The judgment will also make it clear if any attorney's fees were awarded. And then also, let's say the landlord gets a judgment in their favor, then they can go ahead and get this writ of possession from the sheriff. Judgments last 10 years and can be renewed. They can also have interest accruing on them. So, it's tough. Like, most people do not want to have a judgment against them. When we've helped commercial tenants who have been sued in eviction court, we have helped, and this happens in the residential tenant context too. A lot of times the cases are resolved through settlement, so not through trial, where both sides come to an agreement in writing so that it avoids trial and it also avoids a judgment. And the settlement can look different in different situations. So for some people, it looks like, okay, I want to stay there and you're going to let me stay there, but I'm going to make payments, over time for my back due rent. In other cases, it can look like, okay, I'm going to move, but you're going to give me, X amount of time to move and you're going to waive, this amount that I owe you. So it can look different depending on the negotiation. Kavitha, were you going to say something?
Oh yeah, sorry. I was just gonna say, if you do get a lawsuit, definitely try to come to us. Let's see what we can do. If you just you can't pay the rent anymore, maybe we could work out a negotiation for you. And just be really careful with the lawsuit too, because there's very few days to respond to it, especially if you're still in the property, then there's like, probably 5 or 10 days, like very, very small period of time. But the attorney fees thing is big too, because if they win, let's say you owe $5,000 in back rent, but then they take you to trial. You don't you basically think, you know what, it's okay, let them go ahead and get the judgment, but they may then charge you attorney fees, and the attorney fees could be another $5,000. So sometimes it's better to work out a deal with them and a payment plan. So just talk to us and let's see what we can do if that happens to you. But hopefully not. Hopefully that doesn't happen to anyone.
Thanks, Kavitha. Okay, next slide, please. Okay, so this is the end of our formal training. I see some more Q&As, and then I'll also open it up to anybody that wants to ask questions. Resources, yes, we have a commercial leasing guide. This kind of talks about some of the frequently asked questions when it comes to commercial leases. And we also have this new publication on SB 1103. And attached to this publication is a sample notice that qualified commercial tenants can use to notify their landlords that they're a qualified commercial tenant. So in the Q&A, we have Karen's question about, Karin's question about, are UDs for commercial tenants filed in the same court as residential tenants? Yes. So for example, our homelessness prevention team, they often are helping clients that are being evicted in the Stanley Moss Courthouse, which is on Hill Street. That's the same courthouse that a landlord will go to file a commercial eviction case. And in fact, it's the same forms that you use to file the case and to respond. Francisco, are there any assistance or resources to support tenants to answer a UD? There, as Kavitha mentioned, we do try to help people with the UD, but it's a case by case situation because it does take a lot of capacity. And we have hundreds of cases, so it's kind of hard to take on a lot of litigation. I think Bethzetic, I'm pretty sure, and I can find it and link it here, has a guide on how commercial tenants can respond to a UD on their own. So I will link that here. So I would recommend using that. But other than the guide, trying to get a legal aid lawyer, or, there are some tenants that pay commercial UD attorneys to defend them. But what I've seen is those attorneys cost like $5,000 to $10,000, which most of our clients don't have. So I understand that, it's not an option for a lot of people.
Mhm.
Somebody asked, who pays for the eviction notice, tenant or landlord? I'm not sure what you mean. Basically, the eviction lawsuit, the summons and complaint to file that costs like, I think it's like $500 now for the landlord. The tenant, when they respond, also has to pay to respond, but most of our clients apply for a fee waiver, so then they don't have to pay any fee to respond. Sometimes landlords will say, like when we're trying to negotiate with them, that, oh, if we're going to negotiate, then your client has to pay us for our fees that we had to spend to file this case. But a lot of times we're able to get those fees waived through negotiation. So let me know if I didn't answer your question, anonymous attendee.
Oh, and then also, you guys, for the person who asked about the unlawful detainers, like if you do get an eviction lawsuit, even if we can't take on your case to help you, because we don't always do litigation, we can point you to the right direction. We could say, okay, here's your fee waiver, here's a link for how to respond, here's an example, right? So it can get you going and you would probably be able to file something. It doesn't have to look perfect. Even if you just put one defense on there, it would get you the time to negotiate something. So go ahead and, give us a call or give Bet Zedek a call, either one, and just say, look, it's urgent. I got a lawsuit and I have to respond to it immediately. And just remember, you only have like 10 days to respond. So, especially if you're still staying there. So just remember to reach out. Go ahead.
Yeah, one thing I forgot to note is if you don't respond, I think Kavitha was saying this too, is the landlord can get a default judgment against you, which basically
Yeah.
means they won, and then they can go get that writ from the sheriff, and then that writ will be posted on your property, and you'll just have a couple number of days to move out then. It's very fast. So you do want to respond. However, you can get a response in, even if it's just like a general denial, you do want to get some kind of response in.
Yeah.
Francisco, what can you do when the tenant never got a lease or they lost it? Okay. I mean, if they never, so some of our clients don't have a lease. Everything was oral. It was just an oral agreement. There's no requirement that you have a written lease to rent property, in California as a small business. But let's say there was a lease and they just lost it. You can always ask your landlord for a copy of it. I do think that I don't know that there's a requirement that they provide it to you, but I would hope that they would provide it because it's kind of hard to know how to follow the rules if you can't even see the lease. Um, I think it's good to have a copy of it if there was one. In terms of whether it's better or not to have a written lease versus an oral agreement, I think there are pros and cons to each one. Because if you have a written lease, it's good because the expectations are very clear. People can't, go back on their word because sometimes with oral agreements, the landlord will say, "Oh, I never said that," you know? That way the written lease is good. Having the lease for a certain amount of time can be good because then the tenant doesn't have to worry. Like, oh, during these 3 years, I'm set. I'm going to be a tenant here. This landlord can't just give me a 30-day notice or 60-day notice to move. But then we have clients that don't really, they want to have flexibility, right? If they signed a 5-year lease and COVID happened, they feel like, oh, I wish I didn't sign that because I would like to just move out. So you have to think about the pros and cons. For some tenants, like a 1-year lease is sufficient with an option to renew so that as that lease is ending, they can tell their landlord, hey, yeah, I'd like to add another year. So it's good to kind of reserve that option to renew and maybe start with the shorter lease. Um, Hopefully that answers your question. For e-bull, it's 10 calendar days. Wait, it's 10. Hold on. It might be 10. Wait. The rules changed, so I have to double check. Let me look it up. It used to be 5. business days, I think. And now it might
It's
be
10,
10
I think it's
business,
10 days.
10 days. Okay, I'll double check. I'll double check. Um, Okay, yes, Alicia, the UD document, it's UD 105 is the document. We can put it in the chat. Um, Francisco, I don't know of any low-income attorneys. The attorneys that I was mentioning that charge 5 to 10K, they are like not really the lawyers that work at big firms. They're like smaller firms that I think actually are more affordable. It's just very expensive because like these cases can take several hours to litigate. And so these attorneys do charge quite a bit. Pierre, can you think of a scenario where it may not be advantageous to raise these tenant protections to a landlord if our agency is eligible? I mean, it really depends, Pierre. I don't know what your specific situation looks like, if you're under a long-term lease or if you're month to month. You know, the thing is, if you're a month-to-month tenant and you raise these protections, which you have a right to raise, that you fall under 1103, it's possible that your landlord could decide, you know what, I just don't really want to rent to you guys anymore, and I'm going to give you that 60-day notice because you've been here a year. It's possible that could happen, so I think that is a risk. But if you want to talk more, Pierre, you can always email us and we can talk to you offline. Let me look up the calendar versus business days for the 10 days to respond. And then we have Swan here saying, I have a client who mentioned she's been sued twice because her website was not compliant with the ADA. Although she has settled both cases, it's negatively impacted her cafe. Swan, maybe we can help. Just you can put her in touch with us and we'll see how we might be able to help. Yes, because you can get sued for the physical ADA issues, but also if you have a website for your business and it doesn't comply with the ADA. So best to either not have a website if you're not able to get somebody to scan it and ensure that it complies, and there are agencies that do that. Um, because if you have one and it's not compliant, you could get sued. So you need to look out for that. And, you know, as I'm saying all this, I am mindful that it's so hard to run a small business and a nonprofit in California. It's so expensive. There's so many legal things to be aware of. I totally understand that. And I'm sorry that that's the case here. It's a lot. And I do value what all of you are doing. I know it's really tough. And especially now, we're like looking at some tough times. But we appreciate you, and you know we're here to help. Also, for those of you that may not know, LA County is launching a small business grant fund and also a worker grant fund, I think this Thursday, to help businesses that were impacted by the wildfire.
Mm.
You know, I think they're going to help both businesses directly impacted, but also businesses that have been indirectly impacted. So you should apply, you know, just see how it goes. There's a lot of funds that are going to be giving out grants to small business owners. It's just I think what's happening right now is they're gathering all the funds and then they're figuring out an application process for people to be able to apply. So as soon as we know about all of them, we will email our listserv, which I think you guys are on, with the information.
Yeah. Um,
Um, mhm.
Oh yeah, one of the things, yeah, because some of you, even if you were not in Palisades or Eaton or those areas, maybe you have a restaurant or a store and nobody came to shop for 2 or 3 weeks, right? Or it was like so slow, like it's like, what, how could I make this little money this month? And so maybe your customer basis was impacted by that. So if that happened, then, look up the grants. Maybe there's a small grant you can get for that loss. And it sometimes you by saying an explanation of what happened, for example, you don't have to say, well, my sales decreased necessarily unless they ask you that, but that you could say, I have customers from this area and they were not able to, access my services. So if you can explain it in a narrative, what I've understood is they're more likely to grant it. Other thing too that Rachel just brought up is yes, there's a new law that took effect January 1, 2025 for time to respond to unlawful detainer, which is an eviction lawsuit, and you have 10 business days. So the day one is the day after you are served. You don't count weekends, Sundays, court holidays. Yes, so it's 10 business days. But what I would say is I kind of like try to tell myself, oh, I only have 10 days to respond because That way you'll rush and get it done, right? And you don't miss your deadline, and you're gonna go ahead and take care of that fast because you do not want a default judgment. That just means that you lost the case and you blew your deadline. So while weekends don't count, just think in your head, you know what? Let me just calendar 10 days and get this filed.
Thank you, Kavita. Let's see. Okay. Okay, I see Francisco has a question and Lynn. So Lynn, in the event of a building sale, an original lease should apply unless there's something specific. So it does depend, Lynn, on the lease, what it says, right? Because leases will sometimes anticipate a change in ownership of the property. And it also depends if your lease is still effective. So let's say you signed a 10-year lease, right? And it had something in there saying that if the landlord sells the property, then, the lease, like it has some paragraph that addresses this situation. If your lease is still going, yes, the new owner has to abide by your lease. If you're month to month though, right, I would say that the new owner, like the old owner could give you a notice of termination of your tenancy because they're not obligated by any contract to have you there as a tenant. Um, but yeah, we'd want to look at your lease to see what exactly it says about sale of the property or successors or assignees of the landlord and what would happen. And then Francisco, what if the landlord changes? How does that affect? I think it's similar. The landlord could change, or even the property management company could change. We've had that happen for so many clients. Either the landlord died, for example, or sold the building, or like the same landlord now has a new management company. Again, it's going to depend on what the lease says. What I've noticed is that when a new management company takes over, they're often like much harsher. And we've seen clients that then all of a sudden the management company is like, "Oh, you haven't been paying your proper share of CAM. Now you have to pay more CAM and you owe us all this CAM." So that I've seen a lot. We've seen, so it does happen, and how it impacts the tenant will depend on, what exactly the change was and what the lease says. And we've also had clients, which you may have faced this too, where the whole property is being sold for housing. So all the businesses on the plot of land are told like your tenancy is being terminated. We're selling this whole plot to develop housing. So that's been coming up a lot too. Trying to think about policy interventions to help businesses that are facing that specific situation.
If you know
Yes.
your building, sorry, if you know your building might get sold because you've heard about like a rumor or your landlord's told you like, or someone, an agent has come by and looked at it, so you know it's for sale. You could tell your landlord like, hey, I think you're selling the property. Is that right? Would you be able to make sure that if you do sell it, I am, you can lock in my rent, or I could be, I don't have to pay those CAM fees or whatever. Maybe there's a way the landlord, if you're on good terms with him, can put in some protections for you.
Um, Really good questions. I see Swan's question. I'm going to answer this right now because this comes up a lot. So this tenant is saying their landlord refuses to repair issues like the AC. Can you just stop paying rent? No, 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 no. So commercial tenants, you don't have a right like residential tenants to just withhold rent because the landlord's not keeping up their share of the bargain by the landlord's not doing what they're supposed to do under the lease. The landlord could evict you for that, right? They could say you haven't been paying your rent and it doesn't really matter what your reasoning was. Your remedy in that situation is to sue the landlord, even if it's in small claims court. And I know that's not a great remedy because most people aren't going to sue. And also, if you sue your landlord and you're still a tenant there, it's going to make things very, not a good relationship. So you could try to write a demand letter, letting them know how long it's been since the repairs haven't been made, how it's impacting your business. You can, we do recommend that in your lease, you have a clause that says, if the repairs aren't made, then you have the right to do X, Y, and Z. Because if your lease says that, then you can do it, right? If your lease had said that if you don't make the repairs, landlord, then tenant gets to not pay the rent, or tenant gets to pay for the repairs and withhold that cost from the rent. If your lease says that, then you can do it. But most leases don't say that. They just say landlord has to fix this, tenant has to fix this. So I do not recommend withholding rent if your landlord's not fixing something, unless your lease gives you that right. Um, Tim, I just renewed the lease for 5 years. I realized that I was paying 200 per month more than the actual rent for the entire 2022 year. Can I respect a reduction? I mean, you could. It just depends. I don't know. When you say 200 more, it could be that the rent had gone up, or they were charging you CAM. So I think you'd want to understand, like, were you really paying 200 more per month for how long? Maybe ask for like a ledger or an accounting of your payments for the last whatever 3, 4 years, and then see if you want to request any type of refund or reduction. Um, Pierre, do you have any information regarding the ROU calculation mandates for all leases? No, I'm not familiar with what that is. I'm sorry. Um, what else? Any other questions? So we will send out the slides and the recording and some helpful publications to the folks that register for this webinar. As I said, please reach out if you need legal help for your small business or nonprofit. Please check out some of these publications. And yeah, thank you so much for making time to attend our webinar today.